A statement of truth is more than just words on paper. It is a solemn promise to the court, a personal and legal guarantee that the information provided is honest, accurate, and made in good faith. Yet what happens when that promise is broken? This is the shocking case of Southwark Council's leader, Councillor Cllr Williams, and an alleged act of deception that strikes at the very heart of the justice system. In March 2022, Cllr Williams acknowledged, in writing, that he had referred a serious complaint to Southwark's monitoring officer. That referral was a direct act of involvement in matters concerning the claimants, Joyce and Tunde Iyanolakan. But just over a year later, in July 2023, something changed. Cllr Williams submitted a witness statement to the county court. Under the formal statement of truth, he swore that he had not been involved in any decisions relating to the claimants. This isn't a matter of memory or confusion. It's a clear, irreconcilable contradiction between a written admission and a sworn denial. And it raises grave legal implications. Under Civil Procedure Rule 32.14, knowingly making a false statement of truth can constitute contempt of court, a serious offense punishable by fines, sanctions, or even imprisonment. Moreover, the Bar Standards Handbook, which governs the conduct of legal professionals, strictly prohibits misleading the court, abusing one's role as an advocate, or wasting judicial resources. These aren't technicalities, they're pillars of justice. But the misconduct didn't end there. While the court relied on this false statement, the claimants were excluded from the hearing. The judgment was overturned without their knowledge, using evidence that was demonstrably false. This wasn't just a procedural misstep. It was a denial of due process. It was a violation of Article 6 of the Human Rights Act, the right to a fair trial. Outraged by the injustice, activists and legal advocates began investigating. They uncovered the contradictory documents, exposed the timeline, and brought the deception into the light. Not just for the court, but for the public. Now the road ahead is clear. The legal response must include a formal CPR 32.14 application for contempt of court, a complaint to the Bar Standards Board for professional misconduct, a potential judicial review of the decision made in the claimant's absence, and an application to strike out the council's defense under CPR 3.42b for abuse of process. Because in a democracy governed by the rule of law, no one is above accountability, not even the leader of a London Borough Council. This case is not just about two residents. It is about trust in public office. It is about honesty in the courtroom. And it is about whether the legal system will allow falsehood to triumph over truth. Justice demands an answer, and it starts now.